After the arraignment and the selection of jury in the Crown Court, the prosecution's advocate then tell the jury and the court what happens that day of the situation in hand. They have to tell the case scenario from the start till end. What happens to the case, what happens to the scenario of the case from the start till end according to them. You have to know that this doesn't mean that what really happened, but it is only the story of the prosecution, what according to the prosecution happened. They have to tell the jury. So the prosecution advocate opens the case to the jury, tells the jury what it is about, normally by telling them the story of what allegedly happened on the day in question. After the telling of the story, then prosecution calls the witnesses that want to give evidence in their favor. The prosecution calls the witnesses. Every live witness, for example, giving evidence in person, is called in the witness box, takes the oath, and is asked questions by the prosecution advocate to the elicit their evidence. So once the witness come to the witness box, then he is to be asked by the prosecution about the scenario of the case, what he saw regarding the scenario. If some witness saw the happening of the murder, he shall tell the whole scenario of what he saw. This is called examination in chief. Once the prosecution gets done with their witness, then the other party, the defendant's advocate, can come to the witness box and could ask the witness who has just given the examination in chief the questions that test the veracity, the accuracy of their story. And this is called cross examination. It is necessary, the cross examination is necessary to test the accuracy of their story, of what is they telling is either true or not. At the conclusion of the cross examination, the prosecution advocate may re examine. So, re examination happens after the cross examination and it is occurred by the prosecution advocate. And prosecution advocate tells the court and tells the witness and asks him the question that arose out of the cross examination that were not known in the examination in chief. The judge is entitled to ask the question at any stage. So, whatever the time may be during this hearing of the evidence by the witnesses, the judge is entitled to ask the question to the witnesses. Once a witness has finished, they are generally free to leave. So, if the defense does not wish to ask question to the witness, so because of the fact that it is might be that evidence may not be disputed, it not be going against their favor, they might not want to ask questions. In that case, cross examination will not happen, and the prosecution also has the right to read the witness statements to the jury.